We are on the bar, and this evening, as previously stated, I am joined by Kudakwashe Masiyenyama. Kuda is a legal practitioner practicing here in Zimbabwe, and as always, he lends us his time and expertise and allows us to probe his mind for no fee note, for no fees, absolutely. So, what a gent. Hi, Kuda.
Hi, Rumbi. How are you?
I'm fantastic. I'm fine. For no fees, this is the only information for free.
Yeah, you can say that again.
Absolutely. I hope I find you well, Kuda. How's it going?
No, I'm keeping. Good to have you back. You weren't around last week.
This is true. Thanks so much. This keeps happening. But no. I'm back now. Thanks so much, Kuda, for holding forward. Now, this evening, we continue on with our discussions in terms of legal issues, and we want to talk about employment law in Zimbabwe. So before I started the show, I actually said, the larger percentage of Zimbabweans are affected because we are employed by someone in one way or the other. And what binds us is, that document that we're going to be talking about, a contract. So this is a very important matter for a lot of people. So I'm excited to be talking about this with you. Kuda, let's get straight into it. Let's talk about this contract. Binder, employer and employee. What are the different types of contracts? I know there are fixed-term contracts and fixed-term contracts and permanent or unfixed contracts of employment. Tell us a little bit about these and the difference between them.
Okay, thank you, Rumbi. So we do have fixed-term contracts. These or maybe should I start by saying there is a legal framework that governs employment in Zimbabwe. You don't get to just go to work or get to employ somebody, and you do as you wish. There is a legal framework that you need to follow and abide with that protects, especially the vulnerable, in this instance, employees. So we have the Labor Act in Zimbabwe, which is in force. It stipulates what needs to be done for a employer-employee relationship to be legally binding, and issues that needs to be followed. So it stipulates, this is where we then have these different types of contracts coming up. So we do have fixed-term contracts. I believe was in Zimbabwe were fixed-term contracts because of one reason or the other that we will explore as we continue with the discussion. So a fixed-term contract is a contract that has got an expiry date saying you are employed for 3 months from January, February, March, then it expires. That's fixed term. Or it states that it's going to be a 6-month contract, a 1-year contract. It all differs. But the bottom line is that it will be specific to say the contract will be running from a certain date to a certain date, then it terminates. And normally it will then state that it will be renewable upon its expiry on certain conditions as well. So people can have 3-month contract, 1-month contract, 6-month contract, 1-year contract, 3 years contract. So that's a fixed-term contract. We also have then what we call permanent contracts. Those are contracts without limit of time, where you be said you are employed on permanent basis in a certain position, and your contract will then state the nature of the contract. We also have what are called casual workers. Those who normally we have this scenario whereby certain work may be available within a certain period of the year.
Oh, like tobacco farmers, for example, where it's seasonal. Okay.
Yes, it's seasonal. So you come to work during the season when there is work. After the work is finished, then you can go find other things to do. The season starts, you come back to work. It's another contract that is there. So this is the difference is mainly they come when it comes to the fact that a permanent contract doesn't stipulate the time at which it will expire. A fixed term contract will state the time at which it will expire. Consequently, there are variances in terms of the legally recognized methods upon which such contracts can be terminated.
Okay, hold on, Kuda. Before we get to termination, I just want to find out something. You talked about contract yakataura kuti rumbi wewe you are employed kuno Capitalk kusvika December 2026 anditi from January 2024 to December 2026 for example. 2026 uya December akasvika. But I'm still employed. I'm not told to leave. What happens to my status? Do I then migrate to become a permanent, someone employed on a permanent basis? How do we deal with that? Also, when the casual contract becomes more regular, what happens in that instance?
Okay, yeah. So we have a term that is loved so much by labor practitioners like myself. The casualization of labor, whereby there is an argument to say you can't give me a seasonal contract or a fixed term contract when there is work of a permanent nature. So if you are giving me a contract because you want to avoid the legalities of paying certain dues when you want to get rid of me, but it's clear that there is work of a permanent nature because I'm continuously, it's now 10 years, and I keep on being renewed over and over and over again. So there is a debate to that effect. There is a debate to that effect that is about the casualization of labor. But the position took a twist. We do have a Supreme Court decision with that regard, which says there is what we call privilege of contract. And the contract of employment is not exempted. So if what the employer and the employee agreed is that it's a fixed term contract, then the courts have got no business in translating such a contract into a permanent contract. It remains a fixed term contract because that's the intention of the parties is clearly stated in that particular contract. The same then applies when Rumbi has got a 3-year contract with Capitalk. The contract expires, it's not renewed, but Rumbi continues to work. The position is that it doesn't automatically translate to say you are now permanent. It will be interpreted to say you will continue on the same conditions which you were operating with.
Okay, so it remains a fixed term contract. Okay. What sort of benefits are these parties entitled to? Is there a difference between the benefits and allowances that someone on a fixed term contract is entitled to and the benefits that someone on a permanent contract is entitled to?
No, basically there's no difference when it comes to the period during the subsistence of that contract. What only then comes is that that issue which I wanted to mention of termination. That upon termination, for whatever means, what may then be due to the employee will or may differ. For instance, if you are on a fixed term contract, the employer will be obliged to give you a 3 months notice. Say you are on a 1-year contract. it will expire in December. So in even if you are renewing 6-7 times, around this time the employer can give you a notice to say, well, at the expiry of your contract, we are not going to renew. You cannot then come back and claim anything except maybe your leave days, if there are any accruing leave days.
Legitimate expectation. My renewal contract yangu yanga iri 2 years or yanga iri 1 year has been renewed 6 or 7 times. Do I not have a legitimate expectation kuticha renewer futi mova mandisi basa rapera?
You do have an expectation, but it's not legitimate.
It's an illegitimate expectation, is it?
It may not be an illegitimate one. It's just, well, let's call it wishful thinking. Everybody would desire it to work that way from an employee's perspective. But for an expectation to be legitimate, there have to be a positive promise that I'm going to perform. So if you had been promised that, look, we are going to renew, you are going to remain here, look, 2025, 2026, ulingo manager, then suddenly once you are terminated, yes, you may raise my issues a legitimate expectation. But if there has not been any positive undertaking on the part of the employer, where is the legitimacy?
Coming from, I see.
Yeah.
Okay, very important point, because a lot of people will say, so I had an expectation and they want to make it a legitimate one. Let's move on, Kuda, to the next aspect. I think you're starting to touch on it. In what ways can a contract of employment be terminated? What are the legally recognized ways of terminating a contract of employment?
This is a very important one. A very important one, and our listeners, I believe they will get a reality here from both those who are employers and mostly employees. So the Labour Act stipulates circumstances under which a contract of employment can be terminated. And this is in terms of Section 12B of the Labour Act. So it states that, number one, a contract of employment can only be terminated at the instance of the employee, meaning to say, can our employer terminate a contract by resignation. So a resignation is a legally recognized way of terminating employment, a contract of employment. But what the employee is expected to do is to give an adequate notice to the employer working to say, I'm going to resign. So if you are on a permanent contract, you are required to give a 3 months notice. At that time, I will be leaving after 3 months. If you resign with immediate effect, there are consequences, because the employer will then be entitled to recover certain monies from you.
Yeah, let's dwell Ipapapa a little bit. You talked about resignation and eating.
Yes.
A resignation has to be accepted by the employer in order for it to be valid. Ndizvo here zvofamba sei ndikauya ndikangokanda tsamba ndichachandipa napa, here's my resignation ndobva ndabuda ndibva ndaenda.
Yeah, that's a resignation is a unilateral act. It doesn't require the acceptance by the other party. Once you tender your resignation, it doesn't have to be accepted. It takes effect the moment you submit it. So we also have problems whereby employer are frustrated by certain things. Okanda resignation, kwete nokuti ada kuresign, but aroda kubagain something. Then pochizo my issues ekuti pazoitika matalks nechi employers that are all right, so makubvuma manje kuti titaure, can I withdraw my resignation? It's again not possible to withdraw a resignation unless the other part agrees. You cannot then approach the courts to say, within a reasonable time, I actually said I'm withdrawing. The moment, the immediate time you submit your resignation, it takes effect. Ipapo. So a resignation doesn't require acceptance by the other party.
Okay, so resignation has been given. It's a unilateral act.
Yes.
Mati employee kunyangwe zvazo ati panapa and chadi mati pane ma options with immediate effect. So is the money then deducted from my salary or so forth? You talked about 3 months notice being required to be given upon resignation.
Yes. Okay, what happens is this. There is a debate and which appear to be an unending debate that is ongoing to say, at law, if a contract of employment is terminated and the employee intends to challenge that termination, employee attender will get award on property employer on the pretext because I'm challenging. For instance, I'm going to buy a company. I'm going to motor a company. I'm going to cell phone, laptop, any gadget of the employer. And then there is a termination that is effective. And then there are challenges. The matter is still at court to decide whether or not such termination is valid. The law requires you to surrender the employer's property. And then if it's immovable property, you vacate. And you fight your cases while at least you are not in employment. So others raise the same argument to say the employer should also not be allowed to unilaterally deduct any monies that are due to an employee who would have resigned. The employer has got remedies to approach the courts and say, this employee resigned, I gave him or her dues, but I'm not going to notice, so I'm suing them for my man. But another school of thought is saying, no. It's common law, an employer is allowed to say, per calculation, yema terminal benefits ako, do vanda deduct what is due kwandiri. Do it a set off, which is normally practiced. But we are seeing people, other practitioners, rising up to challenge that position.
And which side of the fence, out of interest, do you stand on that issue? Kuda, are you still there? Hello? Oh, well, I certainly hope I haven't spooked Kuda. We will reconnect with Kuda in just a moment. This is On the Bar this evening. We are unpacking employment law in Zimbabwe. A contract achakambomira sei, ano terminatwa zvaitwa sei, what is the employer entitled to and what is the employee entitled to, what conduct is lawful, and we'll be getting into the second segment where we start to touch on unfair and unlawful dismissal. So far, we've talked about the different types of contracts, fixed term contract in a date of termination, or rather a date where the contract starts and ends. Then a contract without limitation of time basically means kuti you are permanent. Hapana zuva rekuti a contract iyoyo ichange ichingogurwa, and then you're entitled to benefits akangofanana, whether you have a fixed term contract or a casual contract or a permanent contract. We're talking there about resignations. That answer, resignation, whether it's accepted or not, it is a unilateral act, and that in itself is enough. So we'll reconnect with Kuda in the second segment. If you've got questions, do shoot them our way on 0719100404. Back with the second segment of On the Bar, and in this edition we are looking at contracts. All right, so we are still trying to reconnect with our guest. That's Masiyenyama, but I will take your questions regardless. This one is coming from you. Okay, I just saw one. Okay, I'm not going to read out what I saw. Lawrence, good evening. You say, so you can just continue working by simply renewing a contract. What about the law that used to say you can't continue to renew contracts, otherwise it becomes permanent? I think this is the aspect that Kuda was talking about, that you have to then, when you're doing that, it's something called legitimate expectation, where you're saying because you continue to do so, you have to then show that there was a legitimate offer or some sort of promise that you would be brought back, and then upon that legitimate expectation, you can actually then say, but I ceased to become an employee on a fixed term, and then you have to give evidence, and then the court decides from there. But it is a case that requires you to come forward, to be diligent, to fight your case. It's something worth fighting for, and particularly where you've been told certain things that will amount to saying Iwa Chatokita permanent. So it's important, but try and get things in writing at every stage. Just insist on having it in writing. Or please, just reduce that into writing. Iwa, send me an email saying that, or you can actually send an email and say, I make reference to the conversation we had about this, and then that in itself is a good record. Just an important trick to have up your sleeve, just to keep a paper trail of things going on. Samuel, good evening. You say, as an employee, one is not privy to the legalities when you sign a contract of employment. It's a tricky situation. True, but here's my advice. Before you sign anything, take that document and have it reviewed by somebody who knows. Kana ukachaga lawyer and say, please review this contract for me. You're not forced to sign a contract before you've read it. There's absolutely nothing wrong with you saying, can I take this away and bring it back? If you've got any issues, auto highlighter before you sign, because ukasigna was a highlighter afterwards, you are bound. Tinoti in the legal circles, caveat subscriptor, which means you're bound by anything you sign, whether you've read it or not. Saga, please, before you sign, just make sure you understand what is happening, and you've got every right to do so. Okay, this one is a different question, so I won't take it now. Thanks so much. We will perhaps post it to a different on the bar discussion. Professor T, good evening. You say, is the employer of house help required to give notice of termination of employment? What are the remedies available if not given? Notice is required, but what you would find with domestic workers is you look at the period of service. Kana mambonzwa kuda achitaura zvekuti, it's something, it's allowable, or you can actually then give notice of 2 weeks in the instance of my domestic workers. But it's good practice in 1 month my notice, sometimes even 3 months notice. It's just good to apply that. If notice is not given, they can then approach their NEC and actually then say that they were not given their notice and claim a notice pay for that requisite notice period. Asi zvakangonaka, whether it's a domestic worker, whether muri kushanda muoffice, kuti kana mangofunga kuti zvichashandi chingopananai notice, it's good practice. It allows the other person to start looking for alternatives. If it is the employee, it allows you as the employer to look for a replacement in good time. This one, an open contract. I think you're talking about a contract without limitation of time. And if I think, because all you need to do when you're signing a contract is see whether the parties are captured, whether if it's a contract of employment, it should state the date of the duration of the contract, when it starts and when it ends, the conditions upon which it can be terminated, things like salary, and then you look also to see those notice periods and so on, and clauses on renewal. This one is from you. Okay. Say good evening to you. You're anonymous, and you say what the law says is not what's happening in some companies that you say are being run by Chinese nationals. You talk about working conditions being deplorable. You're talking about sick leave not being given, and several things not being practiced. As long as if anyone else from a different nation comes and sets up shop in Zimbabwe, they are bound by the laws of Zimbabwe. As such, they should follow follow them. These laws around labor laws, they're constitutional as well, talk about having a safe and hazard-free work environment. They also talk about allowing and ensuring that employees enjoy all the allowances as well as leave days they're entitled to. So if your working conditions are not up to the standard as set by law, please go and report to your NEC, and these issues can be dealt with. Musacha Makanyarara, it doesn't matter that the company is owned by foreign nationals. They're bound by the laws of this country when they're operating here. This one says... okay. Oh, Majgasaza. All right. Thanks. Nice to know. All right. We will be getting to the news at exactly 7 o'clock. I'm seeing your messages coming in. Thanks so much for all the engagement on the bar this evening. Contracts of employment. I knew that we were going to have a lot of questions. So we'll have to continue with the other parts of the conversation, unlawful dismissal and remedies. Perhaps next week when we can get a hold of Kuda. We seem to have lost him, but I will still answer your questions as they come in. This one's from you, Raymond. You say, Maizoi Mazwa, Anoshakaoma big time. Anzi... the law seems to always be on the side of the employer because ndoko vano wana much better offers than the worker, especially these days. I don't know about that. I feel like, maybe let me put it in this way. If you are an NEC graded worker, this means you're not a manager. You're not in a managerial position. You are graded NEC for your industry. So if it's us, it would be Digital and Broadcasting NEC, it's catering and hospitality NEC. So they've got grades for each position. And so you are then supposed to be paid according to the grade. If anything happens between you and the employer, they encourage the conciliation, kuyana nisana first. So you will have 3 attempts for conciliation, and the aim there is kuti musangane and to settle the issue. If that fails, then yopuzwa kumberi poitwa anonzi arbitration. If that then fails, then you continue on, and then if you want to then register orders and then take it up to court. But the idea is we want to do the alternative dispute resolution, right? So that's what then what happens. So I don't know if it's safe to say that it's on the employer side. Sometimes employees don't understand the process. Sometimes they're frustrated. Other times they actually don't file on time and so forth. So I don't know whether it's accurate to say that, Anonymous. This one says, just understand on the recovery of notice not given, if this can be explained again. Where is it in the Act? Has there been a recent case where there was dismissal after the employer wanted to recover notice period not given? I think in this one, it's a contentious one because on one side, they say that the employer should not deduct anything. They should wait until they've taken the employee to court and said, Hanak Badara notice. In practice, though, what will happen is in indikapa resignation yangu and zonzi dovanati with immediate effect, they will write back to me and say, okay, your resignation is noted and accepted. We owe you 90 leave days, also these benefits, this salary, but you did not give notice, so we're deducting that. And then what you'll get at the end has already been deducted. It's probably an issue where what they're holding in your name is less than what you owe. So those situations happen. So a lot of the time, because remember who's doing the payroll is the employer. Ano garango ango deducta mariatu. But it's contentious, as Kuda says, that there is a lot of debate around that, and the jury is not out yet. This one is from you, Mama Madison Jr. You say, hi, Maiza Wiko Inunzi. Weaving pagu resigner inoreve. I'm not sure what you mean, Pamwen. To pay a bit more context. Weaving kutichi. I'm not familiar with this one. Pamamukandipa a bit more information, Mama Madison Jr., and then I can come in and assist on that one. 0719 100 404. We are on the bar this evening and dissecting the issue of contracts of employment.